So CA firm Think and Company, Lloyds and Company, Manohar and Company respectively were appointed as joint auditors for conducting the stat audit of 3031 of Anithya Limited. They were having differences of opinion with regard to the following points. Manohar and Company wanted to refer to the work of the expert Tanmay in the audit report, but the other joint auditors were not agreeing with the same, as such reference was not relevant to an understanding in the final audit opinion, and also it was not required by the statute. Okay, right. Then after that, certain misstatements affected the information to be included in the MD&A of Anithya Limited annual report, but as they were lower than materiality set for the financial statement, and so according to Lloyds and Company, there was no requirement to perform any procedure on the same. But the other joint auditors were not agreeing on the same for the reason that the information may be reasonably be expected to influence the economic decision of the users, right? So here they are talking about the 620, then 720, other information. For the selected item, the joint auditors were not able to apply the designed audit procedure or the suitable alternative procedure and wanted to treat that item as a misstatement in case of test of control as well as in the case of test of detail. But the other joint auditors were not agreeing on the same. Right, so now there is a misstatement identified, right? So SA 530, POC, POD, you've done the sampling and now you've identified a misstatement or a deviation. Manohar and Company had determined for a particular account balance confirmation request, positive confirmation request was necessary to obtain the SAAE, but it had not obtained such confirmation and alternative audit evidence would not have sufficed its requirement. Manohar and Company want to determine its implication on the audit opinion, but the other joint auditors were not agreeing on the same. Limitation on scope, right? So not unable to obtain sufficient appropriate evidence through external confirmation. Differences of opinion and Think and Lloyds were resolved, but there remained disagreement with one of the opinion of Manohar and Company, due to which Manohar and Company expressed his opinion in a separate audit report. Wonderful. Okay. Manohar and Company was initially appointed as a joint auditor in Anithya for 5 years. Yes, 5 years term, but with the other two joint auditors gave its resignation as an auditor to the company on 20th October 2031 due to the reason of having differences of opinion with the other joint auditors. So now there is resignation of the company auditor. Manohar and Company filed the required statement with respect to its resignation on 27th of November 31 with Anithya Limited as well as the ROC respectively. The board of directors of Anithya appointed Namo and Company as a joint auditor in place of Manohar and Company, which was later approved by the members in the general meeting of the company. Namo and Company, before getting appointed as aforesaid, had communicated via a RPAD to the previous joint auditor, Manohar and Company, but the said post was received back with the remarks of his found law. Yes, clause 8, part 1 for schedule. If premises are found locked, what does the clarification of 811 say? Delivered, deemed to be delivered. The request for NOC. Ascertain that the requirements of 139-140 of the Companies Act with respect to its appointment have been duly complied with or not by Anithya Limited. On the basis of the above mentioned facts, you are required to answer the MCQ. Whether the opinion of Manohar and Company for referring to the work of the expert Tanmay in the audit report can be considered as valid. Right? So SA 620 says that one, you should not refer to the work of the expert in case of an unmodified opinion or unless required by law. Modified opinion, you can express an opinion, but you can mention the name of the expert in your report. But even though if you mention the name of the expert, it says CTBR continues to be responsible and the prior permission of the expert is required to be taken. Here, what does it say? Then the reference to the name of the expert was not relevant and it was also not required by any statute. Okay. Right. So, whether the opinion of Manohar for referring the work of the expert can it be considered valid? No, as such reference was not relevant to an understanding of the final audit opinion and it was also not required. Yes, such a reference in the auditor's opinion was relevant to the user's understanding. Other matter, no, as such a reference was not required by law regulation. Yes, if such a reference was relevant to any key audit matter, even though it was not required by any law regulation. Oh my God. Right? So, no, as such reference was not relevant to an understanding of the opinion and it was also not required by any law. Whether the opinion of Lloyds and Company for treating the item as a misstatement in case of TOC. In case of TOC, you find out a deviation, whereas in case of TOD, you come across a misstatement. Which of the joint is which the joint auditors were not able to design the audit procedure for suitable alternative procedure can be considered as following, can be considered as valid. No, as such, the item shall be a misstatement only in case of TOC and TOD. Such the item shall be treated as deviation. Ulta they are writing. If as such the item will be treated as a misstatement for TOC, TOD, it will be treated as a deviation for TOC, TOD. No, as such item will be treated as a misstatement for the test of detail, and the test of control, it will be treated as a deviation, right? So this is the correct combination. For TOD, it's a misstatement, and for TOC, it's a deviation. Okay. Whether the insistence of Manohar and company for determining implications of not obtaining the response to the positive confirmation request on the audit opinion be considered as valid? Yes, so no, because in such case the auditor should have inquired the reasons for the same from the management in writing and included the same in key audit matter. Yes, because in such a case the auditor should have determined the implications for the audit and the auditor's opinion as per 705. No, because in such a case, the auditor should have obtained and relied on the representations of the management as per 580. No, because in such a case, the auditor should have determined to include the emphasis of matter paragraph. So they are roaming around key audit matter, written representation, emphasis of matter. No, no, no. What is right? Yes, because in this case, auditor, you have to determine limitation on scope, implications on the audit and the auditor's opinion. By what date Manohar and company should have filed a statement with respect to its resignation with Anitya as well as with ROC? Right. So when did Manohar resign over that? 20th of October. So once the auditor resigns, within 30 days from the date of resignation, he is required to file the form ADP 3 with the company and the ROC, and in case of a government company, also with the C and AG. Right, so Manohar and company should have filed the statement in form ADP 3423. Right, so it's not 4 and 2, it is ADP 3. And within 30 days from the date of resignation. So now when is this fellow resigned? 20th of October. That means by 19th of November 2031. Okay. Namo and company would be considered to have satisfied the requirements of communicating with the previous auditor. So they sent the registered post acknowledgement due, but office found to be locked. So what did we say? Deemed to be delivered. Right? No, as the communication through RPAD could not be done, Namo and company should have tried an alternative form of communication as prescribed by the council. Yes, it should be deemed as yes, that the post was delivered. No, because in such a case, Namo and company should have informed the Council of ICAI with respect to the non-delivery of the post to the previous auditor, along with the reasons for the same. No, however, Namo and company can commence the audit but should try to satisfy the requirement of communication with the previous auditor at least before signing the audit report. I know, what are they saying? No. What does it say? Yes, it should be deemed as that the post was delivered because officers found locked, premises deemed to found locked, it says deemed to be delivered. Okay, right? So we've come a long way, right? So many MCQs we've completed this time.